to share my screen. All right. As always, we got people. All right. Good morning, everybody. With people jumping in still. I love this. Don't get volunteer. I figured today we just noticed yesterday that Trek updated their IABS, the form that we use. It's the first step in everything we do with any client out there before they're a client. And the changes were minor, but I figured this is the fundamentals. We should probably just go over that again. Not only the changed form, what changed, but why we use it and who's responsible for it. Obviously, we are, but what's the point and why is it the first in the process? And go through a few of those things. We may not take the whole time today, but this really it's recorded for a lot of our newer agents. Can go back and review this later as well, because this is fundamental in our process as real estate agents in the state of Texas. So here we go. All right. So I wanted to point out that we have these two basically entities that we are associated with in the state of Texas as realtors. Now, as realtors, we're members of the Texas Realtor Association. Okay. And every one of our MLSs that I know of are realtor owned in the state of Texas. That's not the same everywhere else in the nation. There are independent independent MLSs that are not realtor owned. But in this case, the realtor associations own the local MLS that we pay to have access to. So we've got to be realtor members, which means all of this, the lawsuits and the settlement and the buyer tenant reps all stem from our relationship and our membership in the National Association of Realtors, the Texas Realtors, and of course, locally here, the Houston Association of Realtors. So there's that entity. And then we have the entity of TREC, right? The Texas Real Estate Commission, which is a state agency that is a consumer protection agency where we get our license, all our qualifications to become agents, to become realtors, our education, to maintain our license is really about that. So they provide forms and documents to protect the consumer. And we blend those things together as a required practice for us as real estate agents to do our job and to do it properly and to be in compliance with the state and with our membership with the National Association of Realtors. Now, oftentimes they can get confusing though, but there's a reason why the state-run TREC and the forms we use for them are required under the law because they're passed by the state legislature and run through the Texas Real Estate Commission. So that under our licensure, this is what we have to do to operate with our license and to stay in good compliance. Texas Realtors provides documents for us to do our business so we don't get in trouble by practicing law, that we fill out forms that they've promulgated for us that are part of our industry, our trade, if you will. And oftentimes these can be blurred. Mr. Leonard, I'm sure, can talk all about that. But I wanted to kind of break this down a bit with the IABS. It's a TREC required form. It's a consumer protection form. But so up here, TREC forms are required because under the law, we require. So the information about brokerage services. It's also a Texas Realtors copy form, TXR 2501. The consumer protection notice, which we have in our email and our websites and so forth, which is another, consumer protection. Hey, this is where you contact when you have a problem that you might think be a license or something where the consumer may be harmed. They provide purchase contracts and purchase addenda for us to use and amendments because those are the buyers, the consumer that are purchasing real estate. This is about informing and protecting them. Okay. So those are why we were required to use these forms. And of course, the flood notice, I got a typo there, but it's TREC form 54.0. In 2023, the legislature passed legislation around flood zones. Now, it's not a flood addendum. This is a notice that the landlord on rental properties is aware or not aware that it was in a flood zone. Whatever, it's never flooded before, will never flood in the future. The point is it's still required for leases. And it's a TREC required form because the Texas legislature passed this law. This still comes up quite a bit in broker review. And so I want to make sure you guys are all aware. This is not something HomeSmart requiring. This is something that the Texas is requiring for us to provide. Okay. Now, Texas Realtors, the trade organization that we are members of, obviously protects us, our licensure, Yes, even temporary leases. Thanks, Don. It's very good. So the flood notice is also for the temporary leases on a sale where a seller stays longer after the close, or the buyer occupancy before the closing. The Texas Realtors, like I said, they provide the other documents. Think about this. They provide listing agreements. They provide buyer agency agreements around compensation. They provide the lease agreements, commercial agreements and leases, all the other things, right? But these are people, and generally are different types of real estate we perform that doesn't have as much scrutiny and state oversight on it. We still are under our licensure. We still have a duty for that. But these are forms that help us do our trade, if you will. Let's see here. And Don will watch that for me. Okay, on that note, so the IABS. So the information about brokerage services now clarifies, just like everything else has been a change, is about that any brokerage fees are not set by law and are negotiable. The new form is available for voluntary use until April 1st before it becomes mandatory. As you know, and we've seen in the recent past, they'll remove the old form pretty soon, and this will be mandatory before it's mandatory. So I would guess by the end of the month, we'll only have this form available. So start using it now. Update. We just had I sent an email out a week or two ago about updating our IABS based around the delegated supervisors anyway. So update your forms with the new form. Add your delegated supervisor. We'll talk more about that in a second as well, just so you have clarity around it. Okay. And here comes Sue. And this is all coming from the Shrek website as well, so you can look at it. But just as a refresher, and for many of you that are new or just don't think about it much on a regular basis, brokers and sales agents are required by law, Texas law, to provide a written notice regarding information about brokerage services at the first substantive communication with the prospective buyer, tenant, seller, and landlord concerning specific real property by using the IABS form. Okay, now we've talked about this. This is not an open house, but if you start talking specifically about real estate at any point in time, you've got to provide this to them, a copy of this, a filled out copy. And of course, we at HomeSmart, when your transaction documents, we want a signed copy. So we know that you provided a copy of it to your client, your buyer, your seller, your landlord, your tenant, and so forth, so that you know you've talked about what agency is, what representation is, and that they at least understood by acknowledging the receipt of the form. Okay. The IABS form is a document that outlines the role of brokers and sales agents in a real estate transaction, and it's divided into 5 sections. It covers real estate license holder types, obviously broker, sales agent, and so forth. That brokers legally required duties, what representation is in a nutshell, written agreements and commissions, and then, of course, contact information for the broker and sales agent. Okay, this is the breakdown of the form. We've all seen it. But I think all too many times we use it, and we need to have realize this is a great way to start a conversation with the buyer, potential buyer or seller, saying, "Hey, this is very professional. Not only is it required, but you should know what your choices are before we get started." Okay. Obviously, we can provide the form in different ways. Of course, we can provide it on our website. It's got to be accessible on the page there. License holders must post a completed IABS form on the homepage of their business website in a readily noticeable place. A business website is a website controlled by the license holder, accessible to the public, and that contains information about a license holder's real estate brokerage services. All of your HomeSmart websites have a link to your IABS and the Consumer Protection Notice, the most recent one, 5.1. The text with a hyperlink must either say Texas Real Estate Commission information about brokerage services in at least 10-point font. I see a lot of ones that aren't like this on our emails and so forth. Or track information about brokerage services in at least 12-point font. So you can do it either way, but those are the prescriptive ways of how it has to be written and linked to in your communication and your website. If your social media pages are being used as a business website, those pages must also comply. You can post a link in the IABS in your bio or about you section, or insert a link to your compliant homepage where your IABS is properly displayed. These are all from TREC. The idea is that this is one of the first things when we get a complaint, a TREC complaint, the TREC investigator will ask us, all the websites, our main website and the agent websites, to have a link to them so they can verify that the Consumer Protection Notice and the IABS is linked properly. So this is important to us. All right, we have a choice about delivering to the party. When it comes to time to deliver or provide the IABS to a party, a license holder could do this in several ways, including printing a copy of the completed document and handing it to the consumer. This is why we have you sign it, whether it be electronic sign or in person, so that they know that they've received it. Here, more coming in. We can attach the completed IABS to an email and mentioning in the body of the email that we have attached the form. We can insert a hyperlink. These are all ways to deliver the information. Once again, for your transaction file, we want it signed by the buyer, the person you represent. Okay. All right, so let's look at the form. And the form we've seen a dozen times, but the new form will have on top the February 10th, 2025 notice. You know that you're using the proper form. The form is broken down, obviously, in 5 sections that we talked about. I broke it down in 3 just so you saw it. The first part is types of real estate license holders. Obviously, we know a broker who is responsible for all brokerage activities, including acts performed by the sales agents sponsored by the broker. That would be me in this case. A sales agent is anybody sponsored by the broker and works with clients on behalf of the broker. Now, that can be brokers themselves that are associated with our firm. That could be agents, but those are anybody that's sponsored by HomeSmart and therefore sponsored by me would be a sales agent as far as the IABS is concerned. Okay, and then this is the one that you might want to spend some time on. Once they become your client, where you represent them, there's some minimum duties here where a broker represents. This is coming from the brokerage, myself, and the agents. Is we put the interests of the client above all others, including the broker's own interests. This is called a fiduciary duty. It's akin to an attorney where we have to put our client's interest above our own. Some states have a statutory duty where there would be no harm. Our duty is much higher. So there's a duty for us to know and to do things that we wouldn't have to do in other states on behalf of our client. Okay. So we have a duty to inform the client of any material information about the property or the transaction received by the broker, answer the client's questions, and present any offer to or counteroffer from the client, and treat all parties to a real estate transaction honestly and fairly. Those are our minimum duties. Of course, we go above and beyond that with our code of ethics, but we're explaining to a brand new potential client, buyer, tenant, landlord, seller, or whatever, of our duties to all people, and then our duties in the transaction itself. Okay. So the next section, obviously, we're going to go through it. You can spend some time with your. This shows your expertise and your professionalism as well. And so the potential client has choices. So a license holder can represent a party in a real estate transaction. They can do it in different ways. We can, as an agent for the owner, the seller, or landlord, the broker becomes a property owner's agent through an agreement with the owner in writing, listing to sell a property or property management agreement, which we don't do here. An owner's agent must perform the broker's minimum duties above and must inform the owner of any material information about the property or transaction known by the agent, including information disclosed to the agent or sub-agent by the buyer or buyer's agents. This is interesting. So when they sign an agreement with you, now that you are their agent, you have the minimum duties owed, plus you have this extra duty that if you learn anything from a buyer's agent or buyer, you have a duty, an obligation to inform your seller or landlord of what you found out. Okay. And owner's agent's fees are not set by law and are fully negotiable. It's been added, right? This is talking about a relationship and an agency agreement with a seller or landlord. Okay. We can represent the buyer or the tenant. The broker becomes buyer or tenant's agent by agreeing to represent the buyer, usually through a written representation agreement. We know that's a 1501 for us. A buyer's agent must perform the broker's minimum duties above and must inform the buyer of any material information about the property or transaction known by the agent, including information disclosed to the agent by the seller or seller's agent. Again, the additional duties is we've got to disclose to our now our client, the buyer or the tenant in this case, anything we know about the property, anything we've learned from the listing agent, anything we've learned from the seller about the property, we have a duty to share that with our client. And of course, again, they're referenced that a buyer or tenant's agent's fees are not set by law and are fully negotiable. And then it goes on to talk about, and the agent can act as an intermediary. It says, as for both. And we get this question a lot. Can I represent both? And no, you can't. You can be an intermediary. Now, I know it seems like it's mincing words, but you have to understand what an intermediary is. An intermediary is you don't no longer have a fiduciary relationship to either side. You've modified those agreements to be basically a non-biased third party. So as an agent for both intermediary, to act as an intermediary between the parties, the broker must first obtain the written agreement of each party to the transaction. The written agreement must state who will pay the broker, and in conspicuous, bold, or underlined print, set forth the broker's obligation as an intermediary. A broker who acts as an intermediary must treat all parties to the transaction impartially and fairly. May, with the party's written consent, appoint a different license holder associated with the broker to each party, owner and buyer, to communicate with the provided opinions and advice to carry out instructions of each party to the transaction. This is interesting. So that's an intermediary with appointments. And then it must not, unless specifically authorized in writing to do so by the party, disclose that the owner will accept a price less than the written asking price, that the buyer will pay more than the asking price, or any confidential information or any other information that a party specifically instructs the broker in writing not to disclose unless required to do so by law. Interesting there. So when you see, if you represent the buyer, you have a duty to disclose to the buyer anything you find out from the seller or the listing agent. And if you represent the seller, you have a duty to disclose to the seller anything you find out from the buyer or the buyer's agent. As an intermediary, you can't. Unless specific, if they tell you can't share it, you can't share it. There's no longer an obligation there to do so. In fact, you're restricted from doing so. So you have to treat all parties impartially and fairly, which can be hard. That's why we don't allow, if you are a principal, if you are the seller or the buyer in a transaction, you cannot do intermediary as well, because it'd be impossible for you to be impartial and fair. Okay. And a license can be, a person can be represented as a sub-agent, meaning a license holder acts as a sub-agent when aiding a buyer in a transaction without an agreement to represent the buyer. A sub-agent can assist the buyer but does not represent the buyer and must place the interest of the owner, the seller, first. This is oftentimes confused, and obviously with the changes in the lawsuit and for the Texas Realtor Association and NAR and HomeSmart requiring a buyer-tenant rep, there probably won't be any sub-agent. But this goes into play if you are working with a buyer but you don't have an agency relationship. You actually have a duty to the seller of the property, and you must disclose it to the person you're working with, and that's a sub-agent. So, and that's why oftentimes when you list a property in any MLS, it asks you how much compensation may be paid to a sub-agent who is not does not have a representation agreement. Like I said, this is still included. Much more rare now because of the requirement to have a buyer-tenant rep agreement before showing properties. Okay. Then to avoid disputes, all agreements between you and the broker should be in writing and clearly establish the following: the broker's duties and responsibilities to you, that's your agency agreement, and your obligations under the representation agreement, which is the compensation portion. And then who will pay the broker for services provided to you, when payment will be made, and how the payment will be calculated. That's in your buyer-tenant rep, and the buyer-tenant rep clearly spells out that you will make an attempt to get that covered by the seller or the listing broker, but if not, the buyer is responsible. So this is all about compensation and disclosure. So those agreements have to be in writing, and they have to say how you get paid and who you pay and how it's calculated. Okay. So, and then it goes on to license holder contact. This notice is being provided for information purposes. It does not create an obligation for you to use brokerage services. This is a disclosure to the buyer. This is why the very first thing we do with a buyer or tenant or a seller is talk about their choices, talk about what the duties are if they sign an agency agreement with us and the benefits of that or not. And then the information that they need to know of your broker, your brokerage, your designated broker, your designated supervisor, licensed supervisor, if you will, and your information for reference. And so we made a change recently because anybody that has supervisory authority delegated by the broker, myself, has to be a delegated supervisor. Don, of course, the assistant broker, is everybody's delegated supervisor underneath me at my direction. If you are a team member, your team leader would be filled into the place where Don is. If you are a mentee and being mentored by somebody, then we've delegated the mentor as your licensed supervisor for that 3-month or 3 transaction period. This is all a part of TREC rules so that a potential client or customer knows who to contact. Obviously, all of the relevant people that have supervisory oversight over your transactions. And we know that used to be 1 transaction of any new type of activity. There's an increased level of oversight required by the broker, myself, and HomeSmart. They've increased that to 3 transactions. So in order to meet the standards and provide that oversight, we used supervisors, delegated supervision, like assistant broker, like your team leaders, like the mentorship program. So to provide that oversight for those 3 new transactions in any different discipline. I would say that I said that correctly, right, Don? I'm getting there. So anyway, the idea there is it's the way, because obviously one person cannot do it all, but this is the way we do this and provide this information to our potential clients so they know who to contact and the information involved. Okay, I wanted to cover this too, but we talked about TREC and we talked about Texas Realtors. And so we have a list of required documents that we require on transactions. And I kind of wanted to pair those up and why. So we start off with the information about brokerage services, but that's a TREC required form. It's new. It's about disclosing to a potential buyer their options and what that means, what the basic duties are to everybody. And then the additional duties that we're required to do to put their interests above our own at the brokerage level, that they have choices of seller representation, buyer representation, or an intermediary, or as a sub-agent, and what that means to them. Okay, that's the TREC required form, number 1. Your consumer protection notice, a link to it's required by TREC as well. Once again, it's about consumer protection. Then we get into the buyer tenant rep agreement, which is this referenced in your IABS, that it must be done in writing and what it must include around compensation. This is a Texas Realtors requirement because of the settlement. Now, as a member of the trade association, we're required to get this agreement signed before we show a property. It doesn't apply to commercial and it doesn't necessarily apply to rentals, but we require it at HomeSmart because we want to be across the board. You should have representation agreement in writing. So because you've already set the stage for this is what should happen after you make a choice to have representation and a conversation around compensation. That's why this is the next step. We at HomeSmart require the general information and notice form, the Texas Realtors Form 1506. We require it because it covers your license, it covers us as a brokerage, but it also informs the consumer, which is what we're doing. We've given them choices, they've made a choice, now we have a representation agreement. We're informing them about the things they have to be aware of during a transaction. That's a great form, and it covers just about everything that they may face, whether it be surveys or lead-based paint or the transactions for. It's a great form to show your expertise, but also to inform the consumer about how they need to be prepared in the transaction. Okay, so then we're going up, then we're writing contracts. So all the promulgated forms TREC provides are the purchase agreements and the purchase addendum. So we use these because we as realtors and real estate licensees under Texas Real Estate Commission are allowed to fill in the blanks on lawyer prepared documents, promulgated forms prepared for by the attorneys and the state for us to use. Okay, that's why we're not allowed to practice law. So we use the required documents like the 1-to-4 family, or the amendment to the contract, or the third-party financing, or seller financing. All these things are prepared for, again, written in favor of the consumer that's purchasing property, and that's why we require those things. The earnest money receipt, that is a TREC and HomeSmart required. That's one of the things that during an audit, as the broker, we're required to keep all documents, all transaction files for 4 years. We're supposed to have the completed transaction file. One of the things is delivery and copy of the earnest money receipt that we have to have notice of. There are different rules in different states around that. This is a pretty similar no matter where you practice. That's why we asked for a copy of it from title, saying that was earnest money delivered to title and was it delivered on time, because there's an opportunity for the seller to terminate during that period if it wasn't delivered on time. Same thing with the option money as well. But the earnest money, we asked for a copy of it because there's repercussions. And if you put the duties, the interest of your seller or your buyer before your own, you should be looking for that. So the broker's held accountable, and so are you as a licensee. Your HomeSmart disclosures is required by HomeSmart. That's two-part. There's a wire fraud notice and there's a affiliated business notice. I know sometimes this is oftentimes asked, why are we requiring those? That's protecting the corporate model, the company itself, and disclosing to your client, one, to be safe, not to verify anybody is sending them an email about wiring funds. And in the event that they would use one of the affiliated businesses, whether it be our mortgage company or our title company, they're aware that we have a financial interest in those things. And I understand that both title and mortgage are not in Texas, but we still are required to use it from HomeSmart. But it's not a TREC or Texas Realtors. Lead-based paint, it's a federal requirement. And no matter where you're at practicing real estate, anywhere in the nation, you have to use a lead-based paint notice addendum for leases and for sales for any property prior to 1978. And there's a lot of, Don may teach on this as well. It's one of those things where prior to means 77 and older. Some people require up to 78, but the point is there was policy changes there. It's prior to 1978. You've got to include this form. Signed by all parties, buyer and seller, landlord, tenant, agents as well. Okay. Any notices, the mud, pit, other notices, those are a local law, are run by the county and the state as well. The flood disclosure, we already talked about that for leases, all types of leases done by the Texas legislature and TREC required. And of course, anything else required by contract. If you and the buyer and seller negotiate something and they include an addendum or a requirement in there, that is required by contract. We can do a lot more, but it's interesting how these all blend together and knowing who the authority is behind it. That's on the buyer side. The seller side looks very similar, except that you replace the buyer-tenant rep agreement with the listing agreement, which is an agency agreement where you discuss compensation and how the agents are going to be paid in the transaction. Everything else is pretty much the same across the board. All right. Number 8, does it need to be signed by the seller? That is the disclosure. That is a good question. Prior to, I don't know, a year and a half ago, we had both sides sign it. And the answer is only the party you represent. So if you represent the seller, then yes. If you represent the buyer, then no. So the idea is the party you represent is what we require as a company. But the rest of these, either our state or Texas Realtors require. Now, some of the questions have come up too is, what if sometime in the future, we're not Realtor members? And then some of these things will change because some of those are driven by our association and membership with the Association of Realtors. But until then, these are required by those agencies. Let me stop sharing here. All right. Any questions? Obviously, we have a new form, minor changes around compensation being disclosed and negotiable. But it's a good time to look at very basics. When we're talking with anybody else, it always starts with disclosure about our duties to the public, our duties in different types of agency of relationship they have. And it always follows up with the next step, which is, okay, now that you've decided, let's sign an agreement around compensation and my duties to you and your duties to me, whether it be in a listing agreement or a buyer tenant rep agreement, is the very next step. And then it goes into education and disclosure, the general information and notice. All of this happens, up front so that the buyer and the agent are prepared. And then you can go forward and represent them fully based on your agreements in the contract, negotiation, and closing, and so forth. Any questions? People still joining. That's kind of funny. All right. And I'll put it in the chat here. Nope, that's good. Okay. Well, if not, I will, once again, this is recorded. This will be stored on our Real Smart Agent education video courses for future consumption. I will also email out the slide deck and the video afterwards today. I wish you all a great weekend, and we look forward to a successful year. So talk to you guys all later.
Thanks so much.
You're
Thank you,
welcome.
Marty.
Thanks, Marty.